Hello and welcome to the daily newspaper analysis. Today we shall be discussing the newspaper of the 12th of March. So coming to the first article, under a humane constitution. Now the context here is with regards to technological self-determination. This is an idea which has been discussed in the backdrop of the recent Supreme Court judgment on allowing passive euthanasia. Now what do you mean by technological self-determination means that when with the rise of technology, with the intrusion of technology in human life, what is important is that human beings should be given a right to determine how much of technology they want, and it should be the human that should be the master of technology, and it shouldn't result in a scenario where human being is becoming a slave to technology. So that is the context here. Now coming to the issues which have been discussed, the first issue is that of a living will. Now, you all know that in the recent judgment by the Supreme Court on passive euthanasia, the court has accepted the idea of living will or advanced directives. By living will, we simply mean that these are some instructions which are going to be issued by a person specifying about what should be done to him or her in the event of a terminal illness, or for that matter, who is going to decide for that person if he becomes ever in a situation incapable to give a particular directive. Now, the idea here is that what is this living will? This is rather can be analyzed as a manner of a technological self-determination. This is because when a person is going to fall terminally ill, he is going to be given some medical treatments, and some medical technology is what this person is going to utilize. This technology is going to be advanced enough to postpone his death, which in any ways is going to be inevitable. So in that scenario, it should be that person's choice that whether or not he wishes to adopt this particular technology. So it is not being viewed from a medical perspective, but rather from a technological perspective, that this person will have a choice of denying this technology. So that is what is the idea of living will. And in this context, the author has analyzed that how such kind of right an individual should be given with regards to other technologies also. So that is something that is important here. Another thing is the issue of individual choice. Now here you need to understand that the idea of individual choice is something that is given in our constitution under the fundamental rights, and more so under article 21, the right to life and liberty. This article has been discussed elaborately by the Supreme Court. It has been expanded, and this now includes the right to personal autonomy. It includes the right to bodily integrity and human dignity. So if these kinds of rights are what are given to an individual, then this individual choice should be available to an individual to engage with a technology, or for that matter to opt out of a technology without suffering any adverse consequences. This choice is something that citizens are not getting today, and that is a cause of concern. For example, a person might not want to share his bank details, but if all subsidies are going to be given to that person online, then in that manner the person is left with no choice. That individual choice is going to get defeated, and this digitalization is forcing this person to adopt a particular technology, open his privacy. So that is one scenario which can be used as an example here. Another thing is the idea of right to privacy. Now you should all know that in a landmark judgment in the year 2017, right to privacy has been included as a fundamental right. So under this right to privacy also, the power of self-determination should be with an individual with regards to invasive technology. So that is one analysis. Another thing which has been analyzed is that this is an era of rising technology. In the past, many articles also we have discussed about artificial intelligence, we have discussed about Internet of Things. So this is an era where from a simple gadget like a phone to the huge gadgets which are being used by the government, for example, surveillance systems which government is using, satellites which government is using, all of these are something that are surrounding us. This is an era of rise of technology, and it is for this reason that a debate is what is important upon self-determination and these constitutional rights which we as citizens have. These rights were at that point of time, because at that point of time such kind of pervasive technology and intrusive technology did not exist. So those rights were limited to the state only. But now with the change in era, these rights should be extended to the domain of technology also. So that is another analysis which has been given here. Another idea is with regards to benefit to user. Now here you need to understand that often whenever a defense for such kind of technology is to be given, then it is said that this technology is somehow in the benefit of human. For example, even in this case of passive euthanasia, if these high-end medical technology is something that is available, for example, a ventilator machine is available which can postpone the death of a person by many days, then it is said that this technology is something for the welfare of humans. But whether or not it is causing a benefit to a human is something to be decided by an individual himself. Such kind of arguments cannot override the human freedom and the human choice which inherently every person should have. So that is the criticism against this defense of benefit to user. So that is one analysis which has been given. Another idea is that individuals should be treated as a citizen and not as a subject. The state is subordinate to the citizen, it is not superior to the citizen. And that as a result of which no state can force or coerce an individual for adopting any particular technology. Even in this case of passive euthanasia, what we had seen was that previously the state was not allowing it because of maintaining some idea of morality and not taking away the life of an individual. But this was taking away an individual choice. So in that context, if you analyze, the citizen is being the supreme, should decide for himself, and it should not be something that the state is forcing on an individual. In this context, two examples is what you can use. For example, the idea of big data. Now, this big data is something that is making individual a subject. It is taking away the autonomy of an individual. Another issue can be the issue of Aadhaar. Here again, the state has said that for the benefit of the citizen, which we can analyze from the fifth point also, that for the benefit of the citizen, some degree of loss of privacy is something that is justified. Now, this is one criticism which the editorial is making, that such kind of statements or such kind of decisions by the government cannot be welcomed in a time or in an era of individual rights and individual self-determination. So that is one analysis. Another thing is with regards to the principle of technological self-determination. Now, as this is the context only, and this is a key word which you should use. This has been said as a principle in this particular article, which means that it will be the individual who will have a determination with regards to use of technology, and neither the technology nor the state nor the capitalists will decide and make technology intrusive upon human life. So that is something that has been analyzed. Another important analysis is with regards to judicial legislation. Now you need to understand here that in the issue of passive euthanasia, this is a case of judicial legislation. The parliament was making a law on passive euthanasia, but in the vacuum of the law, the Supreme Court itself has laid down some guidelines which shall act as the laws till the time the Parliament is not going to make this law. Similar such cases have been seen in the past also. For example, in the case of Vishakha judgment, there also it was a case of judicial legislation. Now, one defense of judicial legislation is that there is a legislative vacuum, and why should the citizens suffer because of that? If the parliament is unable to come up with a law, then what is the fault of the citizen? And in that vacuum, the judiciary comes to the aid of the citizen and gives the legislation. So that is one defense. But one model is what has been given in this particular editorial, and that is one model which is going to be useful for you. For example, a model of South Africa is what has been given. Now, in this kind of a model, what happens is that if the Supreme Court has to give a particular legislation, then the Supreme Court gives a time frame. And the Supreme Court says that within this time frame, the Parliament should come up with a law. For example, in this case of passive euthanasia itself, the Supreme Court could have given a timeline of, say, maybe 6 months. That in the next 6 months, the Parliament is going to come up with a law on passive euthanasia. Now, failing which, if Parliament is unable to come up with a law in 6 months, then automatically the guidelines given by the Supreme Court shall be considered accepted by the Parliament. So this provides an opportunity for the Parliament to participate in the legislation making process and avoids the criticism against judiciary that it is a case of judicial legislation or it is an overstepping by the judiciary. So that is something that has been analyzed here. Indeed, this is a novel article, and this linking is something that is a de novo aspect, and this is going to be good. That is linking this idea of passive euthanasia with technological self-determination. So that is the relevance here. Now coming to the next article, a welcome quietus. Now this is in the context of the Hadiya case. This I am primarily discussing because this is also linked with the previous article. Again, this issue is one of individual choice. So that is the relevance here. Now coming to some background of this particular case. Now Hadiya is the name of a young woman. She's a 25-year-old girl. In the year 2016, she was found missing from her house, as a result of which her father filed a habeas corpus petition in the court. Later, this girl was found, and it was found that she had converted her religion from Hinduism to Islam. And in the year 2017, she even married a Muslim boy. Now what happened is that after this marriage, her father went to the Kerala High Court, and it was in this Kerala High Court judgment that her marriage was annulled. Now, why was her marriage annulled was because a report was filed by the National Investigation Agency which had said that this was a case of indoctrination. Her religion was transformed or changed because of a form of a brainwashing. It was a case of psychological kidnapping. And all of this resulted in the fact that this girl was coerced into marrying this person, and as a result of which her wedding was annulled by the court. Also, the Kerala High Court made some statements is what this Kerala High Court has made in this regard, and that is something that is going to be important for us. The court has mentioned here that the girl should not have married without her parents' permission. The court also returned her custody to her father and said that an unmarried girl should remain at her house with her father and up till the time when she is not properly settled. So that is one statement which the Kerala High Court has made. Now this is important because this has largely come under criticism. So this is what is vital from the background aspect. Now coming to the issues which have been discussed, the first issue is that of an individual liberty. Now here you need to understand that both religion as well as marriage, it is a matter of personal choice, and these are two areas where a person should have freedom. So if both these areas the girl has not been given freedom, then that is a cause of concern. You should know this judgment by the Kerala High Court has been annulled now by the Supreme Court, and the Supreme Court has upheld her marriage. So this is the entire context and the controversy. So the Supreme Court has again reiterated that individual liberty of a person cannot be dominated. So that is something that is important. Another issue is which you can analyze from here is the fear of radicalization. Now the Muslim community is often feared or treated discriminatingly because it is feared that this community is prone to radicalization. Now this is something that is an irrational accusation against a particular community, and this is a case of discrimination against this particular community, and that is one thing that has been criticized, that can be analyzed from here, that it is so easy, and even it is coming from an institution like the High Court itself, which has accepted such allegations against this particular community. So this Islamophobia which is there, that is one cause of concern. So that is something where this particular example can be used. Another very important aspect is the patriarchal views. Now this has become important is because patriarchy in India is so deep rooted that it is coming from an institution as high as the High Court. You can see that the High Court has said that a 25-year-old girl who is an adult, this girl should stay in her father's custody until she is married. This is nothing but a patriarchal mindset. Also, the court has annulled her marriage because it was a marriage of choice. So this is something that is reflecting the social fabric of the society, and this is where the problem is actually existing. So a change has to come from not only bottom to top but also from top to bottom. So that is one analysis which you can give. Another thing which is very important is with regards to the life choices. Now marriage I told you, religion I told you, both of these are life choices, and issues of life choices of adults is something that the adults should determine, and neither the state nor the society has any right to decide on these issues. This is something that has been reiterated by the Supreme Court. So again, why this article is particularly linked with the previous article, because both the articles are stressing upon the idea of self-determination and individual choices. So that is something that is going to be important in both these articles. So that is also the relevance here. Now coming to the next article, bifurcation and blame. Now the context here is with regards to the special category status to the state of Andhra Pradesh. We have discussed this article in the past also, but there are some new aspects, some newer analysis, so that I shall be limiting my discussion to that. Now coming to the background, first and foremost you need to know that this claim for special category status to Andhra Pradesh is being denied by the finance minister. He has said that he cannot give the special category status primarily in the aftermath of the 14th Finance Commission, as per which special category status does not exist anymore, and as per the recommendations of this Finance Commission, this status is something that cannot be given. However, this article is what has been written by Mr. M. Govind Rao. He was a member himself of the 14th Finance Commission, and he has refuted these claims by the Finance Minister. Now we are going to see how he has refuted. First and foremost, in the background aspect, what you need to know is that the Finance Commission is a constitutional body. It is constituted under Article 280 of the Constitution. So that is something that is important. Now coming to the issues which are important. The issue primarily which is important is with regards to the desirability of providing an asymmetric arrangement among the states on discretionary grounds. Now you should understand here that it is no denying that the center is more powerful than the states. The center has more funds at its disposal compared to the states. So this kind of a redistribution from the center to the states is something that does happen. But what is important is that this should take place on some set principles and some set norms, and this is where the role of the Finance Commission comes to play. But what was happening in the past is that we had a planning commission, and the planning commission used to give some special grants to each state. Now, often these special grants by the planning commission were discretionary, and they were also politically bound. So it is this which really created a problem, and it is being analyzed that is it valid that such kind of discretionary grants be given even today? So that is something that is being analyzed here. Now, first and foremost, you need to know about the constitutional provisions. Now, in total, this kind of discretionary grants being given by the center cannot be outrightly rejected, because definitely there are some states which have more developmental needs, and for that matter, those states have some vulnerabilities. For example, the tax base is not big, they do not have viable state finances, there is an economic backwardness, or there is low population density, there is poor trade. So in such scenario, definitely there are constitutional provisions for discrimination between states. For example, Article 370 of the Constitution provides for such a discretion given to the state of Jammu and Kashmir. Further, it is Article 371 from its section A to H. This talks about special discretionary grants to the northeastern states. So definitely the Constitution does have room for this. But even in the Constitution, these provisions are temporary, transitional, and these are special provisions. And this is not something that is evergreening. So that is one criticism against this particular arrangement even in the Constitution. Another analysis is that this discretion indeed is welcome if it is on some sound grounds. But if it is going to be a political ground, and if it is going to be merely discretionary, then that is something that is going to impact or weaken the basic fabric of federalism within India, and that is something that cannot be allowed. So such practices is what should be denied. Even in this case of Andhra Pradesh, we had discussed, this is largely a political issue. This has become an emotional issue for the state, and that is what is creating a problem here. So that is one analysis which you should know. Another thing is with regards to the 14th Finance Commission. As I told you, this article is largely a defense of the 14th Finance Commission. Now, the author here has said that the 14th Finance Commission, being a constitutional body, it limits its recommendations with regards to constitutional aspects only. And the idea of special category states was something that was mooted by the Planning Commission after the Gadgil report in the year 1969, which means that there is no constitutional mention of or any status to this idea of special category states. So if this is not a constitutional aspect, then how can the 14th Finance Commission ever give a recommendation with regards to the special category states? So here the author is saying that there is no limitation under the 14th Finance Commission to not allow this special category status being given to Andhra Pradesh. So if the government is not giving this particular status, then that is a political question, or that is merely an executive issue, and it should not be the 14th Finance Commission which should be blamed for this. So that is what has been analyzed here. Another thing which is important with regards to the special category status is that this is solely an executive decision. It might not be possible to give this status now, because initially this was given by the Planning Commission, and the Planning Commission, as we all know, has been now erased. So as a result of which, this status cannot be given, but blaming that the 14th Finance Commission is responsible for not being allowed to give a special category status is going to be wrong. So that is one idea which has been given, that this statement by the Finance Minister is a misleading one. So that is the entire analysis here. This issue is going to be important from General Studies paper 2. So that is the relevance. Now coming to the next article, a breakthrough and a gamble. The context here is with regards to the talks between North Korea, US as well as South Korea. This is a landmark or a breakthrough talks because it has come after years of conflict between North Korea and this second block of US and South Korea. So that is the context. Now coming to the issues. The first issue is with regards to security guarantee for North Korea. Now North Korea has said that it is willing to participate in any talks, or for that matter in any agreement, only if there is a security guarantee for North Korea. This is something that is going to be difficult, because you should know that South Korea is not nuclear, whereas North Korea has attained nuclear capabilities. So in this backdrop, US and South Korea conduct annual military exercises in the Korean Peninsula. So it might be difficult to completely suspend these military exercises, and as a result of which this idea of security guarantee for North Korea may not happen as it is expected. So that is one analysis which has been drawn. Another issue is with regards to the reliability of North Korea. Now in the past also many talks is what has held, there have been many agreements, but what is seen is that often North Korea does not stand to its word, and as a result of which questions are being raised that what is going to be the reliability of North Korea. Often it is seen that North Korea gets a food aid, North Korea demands for a food aid or for that matter some funds, and after that this country often backtracks on what it has said on its commitments. So that is one fear which is being raised with regards to the prospective talks. Another thing which is important is reviving of six-party talks. Now here you need to understand that at present only these three countries are the ones who are participating in these talks, but initially there was an idea of a six-party talk, and again the editorial is discussing that this idea of six-party talks is what should be again restored. The six other three parties will include China, it will include Japan, and it will include Russia. So these six countries will form the six party. And if these countries are also included, then indeed the agreement will be a more wholesome one. First and foremost, you need to understand that China is going to be important, primarily because China is the only link with North Korea. So that is one importance of China. Another thing is that importance of Japan is important here because Japan is in the neighborhood of the Korean Peninsula. So any breakout of war in this region impacts Japan the most. Also, Russia has been known to support North Korea. So in that context, Russia should also be brought to the talking tables. So that is the analysis which has been made here. Another thing is with regards to the nuclear issue. Now, at present, it is being said by US and South Korea that North Korea has agreed for denuclearization, but such statements is something that has not come from the end of North Korea. So what is being analyzed here is that it might be difficult to completely denuclearize North Korea. So if that is the scenario, then in such a case, altogether the talk should not be suspended. Rather, a way out should be something that should be determined. For example, you can ask North Korea to completely ban any further tests, or you can ask North Korea to limit its nuclear arsenal, or it should be allowed, or it should be opened for checks by the International Atomic Energy Agency. So like that, these kind of safeguards is something that should be adopted at present rather than completely suspending the talks, because that has reaped no benefit. So that is one analysis. Another thing is that North Korea's economy at present is crippled in the backdrop of the various sanctions which North Korea has faced. So definitely North Korea is at a leverage point. It is going to be more than willing to come up with an agreement, and this is one opportunity which all the other countries should avail with regards to North Korea. So that is something that has been analyzed. This topic is going to be somewhat important with regards to the analysis on Korean Peninsula. So that is going to be the relevance here. Now, based on today's discussion, please try and attempt these questions within a word limit of 150 words. And with this, we finish today's discussion. I thank you all for watching, and I hope to see you tomorrow.